Okay, people, so it's February 22nd, 2018. I don't get this, people. Do you see this? This is what Fraser Health Authority is bringing to court to try and make it so that I can't appeal as a poor person. I was told I could write 3 pages. I wrote 7. Then I was reminded it was only 3, but the lady was going to give me 3.5. So I watered everything down to 3.5 pages. And then when I went back, I was told I couldn't put it in with my motion so that I don't have to pay the $200 for the appeal. But this is what, I don't know what this is, people. I don't know if this is, because they're trying to stop the motion for the, so I don't have to pay the $200. They get to submit this, but I get to submit nothing. Like, seriously, these people are so corrupt. They use the court against the poorest of the poor. So anyway, this is, I just got this, like, I think it was yesterday, 2 days ago. And I'm reading it now, right? Because I have court on the 28th at 9:30 in the morning with, to ask, so I don't have to pay the $200 for the appeal, right? As Fraser Health is now asking me to put a order in, ask for an order to extend it because I missed the date, apparently, as they try and fight against the motion. They're asking it to be dismissed and thrown out. So anyway, I am reading what Justice Bowden, this is his judgment, oral reason for judgment. You can see that. Okay? I read it here, and then they go into this little part in here. I'm telling you, people, I don't trust these people. I really don't. Because as we get into this part, this judge didn't say this. He didn't. He said yes. He said yes, yes. I'm telling you, they're putting words in here that don't belong in here. Do you see any word in here that says yes? I don't see anything in here that says yes. I see nothing. And he didn't say that either. But of course I didn't have money to get my own, but it would have been tweaked anyway, right? But regardless, let's just read what this Justice Bowden has to say. The court, okay, Chorney versus Fraser Health Authority, page 2. 1. Hold on a minute. Okay, you ready? This is an application by the defendant. This is an application by the defendant, the Fraser Health Authority, to strike the pleadings and dismiss the claim of Judy Chorney in file number S171469 regarding a notice of civil claim that was originally filed by Ms. Chorney in February of 2017. 2. It is noted that the claim originally was over 175 pages in length. It has subsequently been reduced and is found in the applicant's binder at tab 7. The notice of civil claim now has been reduced to some 151 pages. That's not true, people. He just took off. That's not true. Because I scratched out a whole bunch of stuff there. Right? I didn't amend the relief sought and the legal basis because I didn't know how to do it. I amended the statement of facts, which equal to 114 pages. I brought it down to 19 pages. But when I went to submit it into the court, they wouldn't take it, remember? That's when I thought I was going to get arrested, because the clerks were having a kerfuffle with not wanting to take it, because they said that they couldn't take it, although I could do what I wanted. Right? And it had to be a drama. It was just a big drama scene. So in the end, I asked them to put it in with the amended part with the lines through it, right? Because you're supposed to draw lines through it and then write above if you're changing something. I did that, plus I typed out the 20 pages and I added in the 20 pages at the expense of almost getting arrested over that because of the hassle that it was to try and file it. Even though it's not acknowledged to be anything of substance. And then the relief sought here is what is it? The relief sought is, we'll do the math right now. This might be a long video, people. I'm tired. I've been so tired. You can't imagine. Okay? So the relief sought is 10 pages. So 10 pages. So 19 and 10 is 29 pages. All right? And then the legal basis is 47. So 47 and 29 pages is 16 carry 1 is 76 pages. So I brought it down to 76 pages only because I didn't draw the lines through the legal basis or the relief sought because I didn't know how to write those. They have my I don't know what they have here. They have my 20 pages. You can see it's right here. There's the 20 pages. That's what Master Taylor told me to write. But it meant nothing. It was just, they're just stonewalling. That's all they're doing, people. They're just stonewalling. Okay? So anyway, I brought it down to what, 76 pages because I didn't do this. I didn't go through each page, people, for those last two sections. But for some reason, this person here seems to think that it's still sitting at 156 pages. 151, oh, sorry, had been reduced down to 151 paragraphs. Oh. So, from 175 pages in length, the notice of civil claim now has been reduced to some 151 paragraphs. Which to these people means absolutely nothing. Right? Just like I didn't show you this one yet, people. You see this? You see the name? Still active. It's not the dollar amount that counts, people. It's the principle. Right? Uncle John just threw a little boy in the garbage can. Right? Because he decided he wanted to go back to a loving family. That basically, you know what? Okay, number 3. Ms. Chorney alleges negligence on the part of the defendant in respect of the treatment. And other aspects of their dealings with Mr. John Duncan. The claim also appears to allege some harm to her. More like to the family, people, to the kids. Right? I'm the representative. I'm the adult. Not from any care to her, but perhaps from the care given to Mr. Duncan. Exactly, I don't get any care, people. I run around with a PSI of 40 to 50 every day. Right? I can't even remember the last time I went to the doctor. Serious. And when I get there, what's going to happen? 4. As to her relationship to Mr. Duncan, Miss Chorney says she is like a daughter to Mr. Duncan, and they have been close friends for many years. However, apparently Mr. Duncan has not been seen by Miss Chorney since February of 2015, and she has not been able to find him. She says that his apparent disappearance has caused her and her family to be depressed. Well, it's obvious they don't care about it because they feed off of suffering people. That's what they do. They enjoy it. Right? That's how they make themselves feel empowered. Right? That's how they stay young. Look at the date on this. This is right there. Affidavit made February 20th, 2018. You notice how they like to pick my birthday? Eh? What is it with my birthday, people, that's so important to these people? There it is. Do you see that one? That one's from Eleanor. This is what the court considers to be a legal document. Do you notice the date on that one? Where is it? Is it right there? Yeah, right there. Notice the date. Notice the date. Just want to point that out. Okay. As to her relationship, okay. Mr. Duncan has not been seen by Miss Chorney since about February 2015, and she has not been able to find him. She says that his apparent disappearance has caused her and her family to be depressed. Well, yeah, it's like a native woman. They don't care, people. They don't care. It's pretty apparent they don't care. They treat Uncle John's family like Uncle John was a native woman that went missing. And then they expect us not to get depressed. Right? Because they feed off your pain and your suffering. 5. Miss Chorney says that at one time she had power of attorney regarding financial matters from Mr. Duncan. No, people, it's not at one time. I've had it. I still have it. I've had it for a long time. Right? The original one is over there in terms of the 1990. Okay, remember when they kept saying there was 2 power of attorneys on there? Yeah, right there. Permanent. October 30th, 1990. And then we went back in October of 2001, because the bank asked to reconfirm. And if you notice, whose name is there, people? It's right there. That hasn't been removed from me yet, people. Andre, please don't. Miss Jorney says that at one time, no, not at one time, people, for a long time, and I still have it. Miss Jorney says, because if that was the case, John would have closed this and not just thrown Andre in the trash. Like, who throws little boys in the trash? Except for maybe evil people, right? Something that crawled out of the gutter, you know? Miss Chorney says that at one time she had power of attorney regarding financial matters from Mr. Duncan, and it may or may not still be in force. It is, people. Nobody's taken me to court to remove me legally from having enduring power of attorney. Enduring power of attorney, people. Continuing power of attorney, people. She did not provide the court with a copy of a power of attorney. Yes, I did. I gave him the official photocopy of the enduring, continuing power of attorney from the Canadian Imperial Bank of Commerce, as it was a power of attorney that related only to financial matters. That's not true, because it says continuing on that form, which is an enduring power of attorney. And when you go into the Power of Attorney Act, under certain sections, it further takes you into the power of attorney that he is talking about. In addition to, we did the living will on the video under duress only because of what was going on with that meeting on February 17th, when the social worker was telling John that he gets to have the best of both worlds and gets to go to Victoria, out to live in the country with somebody that he hasn't seen in years, never mind lived with since he was a freaking child. You know, had no relationship with her or her husband or her daughter, but besides that point. As it was a power of attorney that related only to financial matters, it would not have given her standing to proceed in court against Fraser Health Authority on his behalf. That's not true. So, it just makes me think that I need to follow up with the lawsuit with Canadian Imperial Bank of Commerce, because they're using that enduring power of attorney or continuing power of attorney, which means that if for some reason John went loopity-loop, I would continue on with power of attorney and make decisions on his behalf as a legal, Andre, please, attorney or representative. And being that I looked after him for 25 years plus, and his wife for 6 years, 5, right? By default, I was his representative. 6. In my view, the plaintiff does not have standing to bring this action on behalf of Mr. Duncan. Well, of course not. He was medically kidnapped, shipped around town in a hammock under sedation, like their dirty secret, right? Made it so that he lost his memory, so he couldn't fight and ask for help, because, Andre, please, right? To the extent that her claim alleges a wrong done to Mr. Duncan, they don't care what happened to Mr. Duncan. They don't, people. This health authority does not care what happens to its patients. And they don't care what happens to the family of these patients. And when it comes your time to go to the hospital, there's a high probability they're not going to care about you when you become a patient. It is dismissed. Hold on. Okay, anyway. 5, Miss Chorney says that at one time, no, not at one time, people, I still have it. She had a power of attorney regarding financial matters for Mr. Duncan, and it may or may not still be in force. She did not provide the court with a copy of a power of attorney. Yes, I did. As it was a power of attorney, what did I just say?
Be quiet.
Yes, please. That related only to financial matters, which is not true. It would not give her standing to proceed in court against Fraser Health Authority on his behalf. Yes, it would, people. Even if that was a true statement, yes, it would, because he was illegally drugged against his knowledge. He was being illegally detained. He was illegally and suspiciously and dangerously transported across the water and then rushed to emergency on the other side after being in a healthcare facility of two types for 43 days or whatever it was. You know, they failed to provide him with proper physiotherapy of any kind. They were gaslighting him, right? They were psychologically torturing him. They were constantly accusing him of being confused when it was for their convenience. Like, it's just, it's frightening, people. It's frightening that there are people that are doing this in our healthcare system and the courts are protecting it. 6. In my view, the plaintiff does not have standing to bring this action on behalf of Mr. Duncan. Well, when somebody lives with you for 23 years and you have continuing power of attorney for 25 of those years, and you have his legal will and all his ID and personal possessions or whatever, you looked after his wife for him when nobody else would, I think I'm the perfect candidate to bring an action on behalf of Mr. Duncan. To the extent that her claim alleges a wrong done to Mr. Duncan. He never recovered. He just got sicker. He got injured to the point where he never recovered, lost all his memory, and was used as a test lab for tests within the healthcare system like brain scans that were unnecessary as they were doping him up to justify those procedures so that they could plot and scheme behind his back when he was sleeping 12 hours out of a 12-hour day, 18 hours out of a 24-hour day, sleeping, lots of sleeping, right? It is my view the plaintiff does not have standing to bring this action on behalf of Mr. Duncan. To the extent that her claim alleges a wrong done to Mr. Duncan, it is dismissed. In my view, even assuming the facts alleged are assumed to be true, not that they would care, her claim would not succeed and is bound to fail. Wordplay. So even if everything happened the way I say it happened, people, they don't care. It's bound to fail. Because Uncle John was expected to defend himself after they had done everything that they had done to him and basically destroyed his life and his mind and his body. To the extent, this is 7, to the extent that Mr. Chorney's claim, all of a sudden I become a Mr. Chorney. Now I'm a Mr. Chorney. Exactly, because this thing has been tweaked, people. Somebody's changed it in here, but of course you can't prove that. And because you're not allowed to go into the court with a recording, you'll never get the truth, right? 7. To the extent that Mr. Chorney's claim, because I'll tell you why when we get further into it. To the extent that Mr. Chorney's claim alleges wrongs to herself, the Fraser Health Authority does not owe a duty of care to her because she was not a person in their care or the care of the one of the hospitals within their authority. Exactly. I can never use their hospitals. Exactly, people. I can never use their hospitals. Their hospitals are not safe. There is nothing safe about their hospitals. at least for me. I can't speak for other people, but for me, nothing's safe, and it wasn't safe for John. 8. While I sympathize with Miss Chorney, now I'm a Ms., circumstances, and understand that she misses Mr. Duncan. This is more than missing Mr. Duncan. They've affected the lives of, like I said, my children, my grandchildren, myself, most definitely Mr. Duncan. He suffered for 3 years, people, in silence, as he was being told that he wasn't allowed to talk to us because he wasn't better yet. And they made sure he didn't get better. She misses Mr. Duncan and would like to see him again. Her claim against Fraser Health Authority must be dismissed. In doing so, I have considered the submissions of the applicant and Miss Chorney, and in my view, it is plain and obvious that the claims that I discern from her notice of civil claim would fail. Because it was a mock trial, people. This is on a day when you go into the courtroom and it's filled with a whole bunch of people standing around to be heard by a judge for, 15, 20 minutes or however long that the judge will allow you to stand there and talk, right? And it's overflowing with people to, tell their story, right? And you're expected to tell it in a very short time as you're already predetermined to be judged, prosecuted, and found guilty. This was not a trial, people. It was a mock trial, okay? How can he discern that it was meant to fail if it never went to a real trial and they never looked at the evidence in whole, as a complete whole, right? And what evidence they did look at, they ignored it and they twisted it around to suit their agenda. And in my view, it is plain and obvious that the claim that I discern from her notice of civil claim would fail, even if the alleged facts are assumed to be true. So, mail fraud, insignificant. False pretense, insignificant. Forgery, insignificant. Kidnapping, insignificant. Human trafficking, insignificant. Just the list goes on and on and on under the Criminal Code of Canada, people. And it's all insignificant. Assuming that it's true, it's still insignificant. Because they don't uphold the Criminal Code of Canada. They don't. I refer here to Knight versus Imperial Tobacco Canada Limited. 2011. SCC 42. And Willow versus Chong. 2013 BC Supreme Court 1083. Andre at paragraph 18 regarding the application of Rule 951 of Supreme Court Civil Rules. 9. What does the applicant say about costs? 10. Andre, please. Mr. Buckley, my lord, we are seeking our costs in this matter, and I believe or I submit that we are entitled to do so, as we were successful on our application. 11. The court. Now, was it open to you before Master Taylor to seek the dismissal of the claim? Mr. Buckley. It was not put before Master Taylor. I'm not aware whether that would be within the court 13, a master's jurisdiction. 14, Mr. Buckley, a master's jurisdiction. And the reason it is before a judge's chamber today is that determination of a duty of care, in my opinion, should be put before a judge, a determination on the law. 15, the court. That could be, but I would, and I'm afraid I cannot say whether the master had jurisdiction. But if this could have been dismissed by the master, that would have saved the cost of this hearing. It wasn't a hearing, people. It was not a trial. It was a prosecution to find me guilty. I was already found to be guilty. So therefore, it became a prosecution. There was no trial. Judy Chorney, may I ask something? The court, yes. There's the yes. Judy Chorney, I have on video where Mr. Duncan was asking for a lawyer 2 days before he went missing. 3 days before he went missing. I also have video of him doing a living will, giving me power of attorney over his medical records and whatnot, and who he wanted to live with because of the duress that Fraser Health, the court, yes. Okay, notice how they're importing the yes, because they watch my videos, people. They watch my videos because that's how they play. They play dirty pool. Of course, I don't have to make videos. I don't have to give them anything to run with. But, you know, I think it's important for the public to know exactly what's going on in society. And unfortunately for people like me, you know, we're the canary in the coal mine, and people don't necessarily hear the canary until it's too late, right? So, you know, you don't, just because you don't think it's happening right now, what I'm talking about as a whole, in terms of the corruption within our society and the court system and the health, like the public union sector, really, that's what it's about. Anything that gets paid, you know, en masse in hundreds of thousands of dollars, if not, you know, like up to $1 million, depending on who they are and where they're employed within the union, right? You know, money turns people into the green-eyed monster, and we're dealing with that. Oh, can you hold on, please? Anyway. Why would they do that, people? Do you see that? There's page 3. Supposedly page 4. Anyway. Cheap. Canary in the coal mine, people. Yes. This is 19. 18. Judy Charney. I have on video where Mr. Duncan was asking for a lawyer. Again, this is a mock trial. I shouldn't even be having to say that. That should be in a trial setting, and we should be discussing these videos, right? Which are several videos, people. I have on video where Mr. Duncan was asking for a lawyer 2 days before he went missing. 3 days before he went missing. I also have a video of him doing a living will, giving me power of attorney over his medical records. And again, under the enduring, continuing power of attorney, I had that right. But, you know, they weren't listening, so we brought it online, people. Because we already had it. We already had it, people. But they didn't listen. That's why they never got a lawyer involved. That's why I can't get a lawyer. Right? Because they're caught red-handed. And they know it. So they're going to do everything they can to try and destroy me and my family. Because if they destroy me, they destroy my family. But they started destroying my family a long time ago when they went on the attack to my daughter, right? And then took my grandson 15 months. Right? To prop up that union sector. And then gave me back a broken child as they broke my children. And then they went for the juggler and went for John. And they like to pick days, you know, whether it's Christmas or right before Christmas, or they like to choose birthdays, right? Hoping that that will derail you, right? Because, you know, self-doubt can be a very big factor in how people react to things, right? So the more self-doubt that they can put in you and make you self-doubt yourself, make you hate life, make you depressed, you know, make you scared, make you frightened, you know, get that adrenaline going in your brain, have it shooting like this so that you get permanent brain trauma like Uncle John, the more control they have over you, right? And your loved ones. So that they can survive. That's how they survive, people. That's the services that they provide you as a public servant. Anyway, let's just read for a bit. 18. I have a video of Mr. Duncan. We're asking for a lawyer 2 days, blah, blah, blah. Okay, the court, yes. Judy Chorney. Staff were putting upon us. Okay, I better just read on. I also have a video of him doing a living will, giving me power of attorney over his medical records and whatnot, and who he wanted to live with because of duress that Fraser Health, yes. Staff, okay, the court, yes. 20, Judy Chorney. Staff were putting upon us, and he was scared. He was having nightmares by that time, people. Have that on video too. 21. But regardless, the court doesn't seem that to be important, right? 21, the court. I am not going to continue with this case, ma'am. I have made my decision. So he cut me off in mid-sentence, right? After he told me I only had 5 minutes. This is not the whole. I don't know what that is, people. Like they took out. They obviously have some sort of transcript, and they used some page. Don't know what page it is of the transcript, but it's towards the end, right? And they didn't care whether he was scared. They didn't care whether he wanted a lawyer because he knew that we were up against something very serious. They didn't care that he was under duress to the point where we had to, do videos online to cry out for help because nobody was helping us within the healthcare system outside of keeping him detained and drugged and making it so he couldn't get up, putting him in a broken wheelchair, accusing me of elderly abuse just so they can run me off so they could, put him in a hammock at some point and, transport him in the hall of the ferry, sleeping like a baby, only to rush him off to him. They didn't care about any of that, people. 21, the court. I'm not going to continue with this case, ma'am. I have made my decision. 22. What I will say is that I think it is appropriate that costs only be awarded to the defendant up to, but not including this application because of the uncertainty as to whether or not this matter could have been dealt with by Master Taylor, and in consideration of the fact that Miss Chorney is representing herself and does not have a lawyer. Okay, remember that freebie, that one freebie when it comes to amending a notice of claim? By law, through their court procedures, they have to allow you that one time to make the amendment to your notice of civil claim. So that right there is a contradiction to their own rules. So for them to suggest that Master Taylor had the right to throw out my notice of claim at the first meeting of this person, okay, in terms of Fraser Health putting their application in to throw it out, and then I was in front of a master, and he said, well, you get your one freebie, right? And then I find out to learn that the freebie means I'm entitled to the one time to make the amendment. So they only allowed me one time to, and that was only because under the rule book I was allowed that one time. by law. But they have not allowed me to amend anything else since then. Instead, they've prosecuted me on that day with Master Taylor and tried to make it sound like Master Taylor was at fault for not dismissing it then and making the court pay out all this money, right? I'm wasting their time because it should have been thrown out by Master Taylor when in fact Master Taylor couldn't thrown it out even if he wanted to because I was allowed that one amendment. Do you see the word games, people? Do you see how they play word games? 23, Judy Chorney. I represent Mr. Duncan, sir, and his family, his immediate family. The court, 24. You are the one bringing this action, ma'am, not Mr. Duncan. Well, yeah, not Mr. Duncan, because by that time, he's been so brain damaged, people, tucked off in some freaking care home and forgotten about. He couldn't walk out of there by himself, people. That's why they took him. They made it so that he couldn't walk. And he couldn't walk very good to begin with because of his legs and his eyesight. That's why he had us, and me and the kids. We used to walk with him all the time. Help him walk. Like this, I live in hell, people. Earth is hell. This is hell. This is not justice. My life is a living hell. 25, Judy Chorney. Mr. Duncan can't. He was illegally detained. Exactly. He couldn't represent himself because he was being illegally detained. The court. Yes. Judy Chorney. He was illegally drugged. He was illegally transported. The court. All right. Judy Chorney. He was illegally, the court. All right, Judy Chorney. Hijacked with his finances and the court. Fine. Judy Chorney. For some reason, the court seems to think it's okay to cover that up. 34. The court. No. So costs up to today, but not including today. All right? Just flew over the cuckoo's nest. Didn't give a fuck. Doesn't care. I'm telling you. These people don't care. That's why we have 10,000 people in the province of British Columbia, Canada, that have been illegally detained through unscrupulous methods that do not meet these legislative acts, rules, and regulations. Because the court does nothing about it. Because it's just a cash cow for the court to prop up their pension plans and their wages and everything else that runs through that fucking halls in their, building as a whole. Judy Chorney, 35. But I have the freedom to appeal the court. Absolutely, ma'am. 37, Judy Chorney. I have the freedom to file another one. The court. You have the freedom to appeal the decision if you wish. That's not what he said. He was going, yes, yes, yes. Yes, he was going yes over there, but he was going yes near the end. But if you notice, there's no yes in here. 39, Judy Chorney. And I have the freedom to file another lawsuit. 40, the court. That depends on the lawsuit. That depends what the lawsuit relates to. That's not true. He never said that, people. He said yes. It was yes, I have the right to appeal. Yes. I asked if I had the freedom to file. I didn't say freedom. I asked him if I could file another lawsuit. I didn't say freedom. I said, can I file another lawsuit? He said, yes. He did not say that depends on the lawsuit, what the lawsuit relates to. He did not say that. But we'll never get the truth of it because we're not allowed to bring in our own recorders. We have to rely on those court clerks that type this stuff out for us, right? Which is prejudice and bias. and easy to manipulate. And it's apparent they don't care. So if they don't care, why wouldn't they go to that extreme? Nothing's stopping them. There's nothing that stops these people. They feed off of the pain and the hurt that they put out in society as a collective group of employees that depend on public tax dollars to support their lifestyles. Judy Chorney, 41. Okay. 2. 42. The court. There are rules regarding whether this matter is similar to, and he did not say this, people. He did not say this. My daughter was in court with me. There are rules regarding whether the matter is similar to this or a different matter. You may, if you have a lawsuit on a different matter. He did not say that, people. And what right does he really tell me? What right does he have to tell me what is important to my kids, the future of my grandchildren, or for myself, or even for Uncle John for that matter, right? Because Uncle John still has his room, people, right? It's a very peaceful room, trust me. 42. There are rules regarding whether the matter is similar to this or a different matter. You may if you have a lawsuit on a different matter. No, he did not say that. He said yes, yes, yes. Judy Chorney, no. The court, fine. Judy Chorney, Mr. Duncan is important. The court, all right. Judy Chorney, so is his immediate family. The court, all right. And then he signs it. So I guess it was Justice Bowden who threw out the little boy and the old man and everybody else that was connected to that old man for almost a half of a lifetime. Right? So, I guess I'll be looking at this on the 28th of this month as they're trying to convince whoever I'm in front of that I'm not allowed to be poorer and have the court to actually help me to solve this problem, Shimei's trust account, the Royal Bank, and not to mention just the fact that our life is in limbo and that we have predators in our society that roam our public environments purposely trying to destroy innocent families for profit. And the majority of people who do this are white. In terms of the big wigs, right? You know, the senior union staff. Which then goes into a form of institutional racism. Because my family is a minority family. Right?